All right, well, no matter who the president picks, you can imagine that the so-called normal courtesy call on U.S. senators of both parties could get a little bit more direct, a little more heat, a little more in your face, with each one wanting to know specific answers to specific questions, Roe v. Wade chief among them. Attorney Emily Compagno on that. I just suspect, Emily, that it's going to be a little bit different this go-round, and particularly with senators who want clarity on Roe v. Wade or gay marriage or whatever. They're not going to be satisfied with just sort of a vague response, even though that's the best, a Supreme Court pick could offer them.
I agree. I also point out the fact that even this weekend, Republican Senator Susan Collins said that she won't support a nominee who shows any type of hostility to Roe v. Wade. So it's not even throughout party lines that we're seeing potentially a pushback. Now, in terms of the judges being considered, there isn't that many decisions and that much paperwork that we can analyze. So a lot of it is conjecture. But I do want to point out a few things. Obviously, Amy Barrett has been a focus of the left, in part because of her comments publicly that she believes life begins at conception, as well. A law journal published about the 1992 Planned Parenthood v. Casey case, where she basically said, look, this is an example where courts should be flexible in admitting past errors and overturning them. We have Kavanaugh, who he clerked for Justice Kennedy himself, and he was part of the unsigned order, actually, of the judges that dealt with the illegal immigrant teenager who sought an abortion. Now, that litigation is ongoing. And then we also have, for example, Hardiman. Now, he brought in the Little Sisters of the Poor with the employment case. So people point to these things as conjecturing of how they would rule, and especially with the ancillary issues, right? We've had the 72-hour waiting period hitting Iowa Supreme Court. We have the heartbeat bill. There's a lot of ancillary issues that might provide more light than the actual bedrock right to privacy that Roe v. Wade represents.
There's been talk, Emily, that they would chip away at the Roe v. Wade foundation without directly taking on Roe v. Wade. And to your analysis there, that is the way that this is going to be done, if it's going to be done at all. What do you think?
Right. I think there's a lot of truth to that, in that those ancillary issues are what we've been seeing rising up through the state courts. And I also think that given the trend of the Supreme Court, and given the fact that President Trump is the one nominated under his administration, that likely what we would see is the justices would not ratify any type of activism happening in the lower courts. And so while we would see a trend towards libertarianism, right, and the kind of the right to states and federalism, the right to states to make their own decisions, we wouldn't see anything that wasn't strictly within that compelling state interest, the strict scrutiny that is afforded any type of chipping away at Roe v. Wade. Again, we saw that with that 72-hour waiting period, where the Supreme Court there at Iowa ruled it wasn't in the compelling state's interest. So likely I would see SCOTUS affirming that. But you're right, there's a lot of ancillary issues and bills that are in lower courts now.
All right, Emily, always good having you on to make sense of this craziness. Have a great 4th.
Thank you. You too.
All right, in the meantime,